Greetings to you all who have joined us for this Staples Trust Policy Dialogue Forum today. We are looking at the aftermath of the CAB3 and July 31st. And our question is, after CAB3 and July 31, what is to be done? It is no exaggeration that what we have here is false confidence on the part of the leadership in this country and the fellow purveyors of CAB3, what in English is called a Pyrrhic victory, Pyrrhic. To define Pyrrhic victory, a victory at too great a cost, where the toll or damage suffered makes the win feel like a defeat. Why do we call this a Pyrrhic victory? First, 31st July was a clear indication that the mass of the people, as has been the case from the very beginning, were opposed to CAB3. Secondly, there appears to be vanity on the part of Mnangagwa and his fellow inner circle. Vanity in the expectation that at the age of 88, you are still in control, let alone by 2030. Thirdly, it reflects a fear that blinds an incumbent to ignore the massive opposition that has made it imperative to cancel the 2028 elections and bid for a life presidency. For it is out of fear that dictators are made. Above all, the bare reality that this is a status quo completely untenable, to be reversed ultimately on the back of the inevitable victory of the mass of Zimbabwean people. Today, we have to help us interrogate this question 3-4 eminent persons. We have first and foremost Tendai Biti, who regrettably has had to attend to a family matter. His brother is very ill, but he did this morning something I thought we should quote, and I quote Tendai Biti. Through CAB3, the regime and its multi-layered checkbook choristers have brought the Republic into disrepute. By signing CAB3 into law on 7 July 2016, the cartel committed treason. It reversed the fundamental center of gravity of the liberation struggle, namely one person, one vote, and in the process executed yet another coup against the people of Zimbabwe. And someone commented, if allowed to succeed in Zimbabwe, this new type of power grab could gain traction more broadly, which would gravely harm the process for democracy in Southern Africa and the continent writ large. I thought we should begin with that quote from Tendai Biti not only because he has inadvertently found himself absent in this discussion, but also to set us on the pace to a discussion in which we have other eminent speakers, in particular Lavmo Maduku, our leading constitutional lawyer in Zimbabwe and beyond, who will be followed by Jameson Timber, and then hopefully Douglas Mowanzora, and last but not least, Karen Kazingizi from ZIPA. So let me turn to Professor Maduku without further delay. Professor Maduku.
Thank you very much, Professor Mandaza. I hope I'm being heard.
Okay, you're very clearly. Yes, thank you.
Yes, so I would like to thank you very much for organizing this platform. But I must, of course, start with, expressing our pain over what happened in Kariba, that Kariba boat tragedy, which in all respects shows a complete absence of government in this country. I mean, it's a tragedy that could have been prevented had government been active properly in public transport frameworks. So I just wanted to record that message of sadness. But turning to our topic, I think that we have two clear things that are coming out, and I'm happy that both in your opening statements as the moderator of the program and what you quoted from Tendai Biti, those two things are coming out clearly. Nothing has happened substantively except some meaningless step which ZANU-PF has taken, which President Idi Mnangagwa has taken, which the movers of CAB3 have taken. And that step is this meaningless step of going through these motions in Parliament, getting an endorsement, which was predictable. Then even the president quickly putting a signature and then pronouncing that they now have a new law. But the emptiness of that process is quite apparent. They know that the majority, in fact, overwhelming majority of Zimbabweans would tell you that we haven't started. We are not going to have this thing called the Constitutional Amendment number 3. In other words, we are not going to tolerate a state of affairs where the politicians in government decide that there will be no elections. Not only that, they decide that the president would not respect the term limit that is imposed by the Constitution. They further decide that from now on there will be no direct presidential elections. Now, those kind of things are not tolerable. So, what I would say is that yes, there is a step which has happened, but it is meaningless in terms of substance. No one should say that because it has happened, it will remain the thing to take into account. So I must record the fact that, yes, we now have this amendment, but this opposition to it has not changed in any one respect. And I want to quickly indicate there that when the processes were taking place, we did announce as not just individual groups, ourselves in the NCA and other groups, but as a collective organization. Now we work together with others in Sungano, Yevano, Ubumbano, Lompakati People's Coalition. We did announce that we have two strategies that we will adopt. The first strategy is the legal battles in the courts, and this is first, and then the second strategy would be peaceful, civic, or political action, but peaceful. Now, the first step has already been taken, and we are now waiting for the full process to develop. We have filed no less than 5 applications in the courts, principally in the Constitutional Court, and these are fairly powerful legal arguments or legal position being put across. That step is not taken. So if one were to answer the question, so what next, which is the purpose of today's discussion, what next is the legal actions next? We would expect that these processes would be held from mid-September onwards. We should be already hearing the matters being argued in court and verdicts coming out from the court. We remain very confident that that step of opposition to CAB3 is an important statement by the people of Zimbabwe. We are engaging the remaining arm of the state in respect of CAB3.
We can't hear you now. Professor Madugu.
Or now amendment number.
Can you just go back, because you had gone blank. Professor Madugu. Professor Madugu.
I'm in a meeting, please.
We can't hear you. Professor Madugu, we can't hear you.
Meeting.
Professor Madugu, can't hear you. Professor Madugu. Professor Madugu. Professor Madugu. David.
Yes,
Can you restore Professor Madugu?
I think it is his network. Maybe someone else can come in while we try and figure out what's going on.
No, he's necessarily the first speaker on this.
Yeah, but I think his network is giving him challenges.
Yeah, okay, let's move on to Jameson, member of the coalition, Sungano. Indeed, we have 3 members of the Sungano, the coalition here, necessarily so. So, Jameson Timber, if you can come in, and then we'll get back to Maduku after that. Jameson? Jameson Timber? Jameson Timber? We can't hear you. Jameson Timber? Jameson Timber? David, is it something to do with the
network? Yes, bro. It's the network. But I think Douglas is on.
Let's hear Douglas Monzora, please.
Thank you very much, Mkwasha. I hope people can hear me.
Very well.
Well, after the signing of the CAB3 and the July 31st event.
Sure. What's happening to the network today? We can hear you as well. David, is something wrong with it?
Yeah, I think generally the network is a challenge today.
For every one of them.
Yeah.
Montola is gone.
Yes, his network is also a challenge.
What is happening?
What is it? What are they using?
I don't know. Can you hear me? Anyone?
Yes.
Yeah, I can hear you very clearly.
Well, can I have a go?
We can't hear you.
I think Manzora at the moment, Prof, maybe NECA, because Manzora, I think it's also the network.
Network.
Yeah.
Can Maduku? Can Maduku come back?
I'm hearing you.
Maduku. Hello.
It's not there. I'm here.
Maduku.
Professor Mandaza.
Lava Maduku.
Hello? Yes,
Sorry, we
hello?
lost you.
Yes, I can hear you.
Yes. Can you start again? Because really we have lost you completely.
But yeah, it was my network, but
Hello.
yes, I can start again.
Please do.
All right. Are you hearing me now?
I can hear you. Yes.
So I can begin.
Yes. Please. Please do.
Well, I think I should start. I would say that our topic requires us to say what is next after
Yes.
the enactment of the amendment number 3 and also
Yes.
after 31 July. I would like to say that what has happened, which is the process of having the act now in place signed into law by the president, I would characterize it as a meaningless step. It is there, it is a step that has taken place, yes, but as far as we are concerned politically, it still does not count for anything because the motions of this bill going through parliament and then being signed into law by the president, those motions were already known, they were going to happen. But what is most important is, so what after that has happened? Now, I want to remind our listeners and the public in general that we had announced as a group, not as individuals, it's a group, now a group called Sungano Evanu, Ubumbano Lompakati, People's Coalition, that we were going to have 2 strategies in fighting this attempt to mutilate the constitution. The first strategy was legal, to engage in legal battles. And the second strategy was one of engaging in peaceful, civic, stroke political action. Now, we have already started the first strategy, which is one of going to the courts or fighting in the courts. We have filed no less than 5 applications in the Constitutional Court and other courts. These applications are not small, they are substantive, and they engage one arm of the state that has not been involved all along. Remember, it was the executive cabinet that initiated this unacceptable amendment. Then it was taken to the legislature parliament, which passed this unacceptable amendment. Now we have approached the judiciary, which is the third arm of the state, to intervene and determine whether or not what has happened is lawful or what has happened can be tolerated by our legal framework. That's where we are. So we are perfectly within the framework of what we are permitted by the Constitution. And these challenges we urge the people to take them seriously. What we can say is that if we are to say what next, the answer is simple. The first next stage has been to challenge the amendment in court. If we succeed in the cause, then the next thing about CAB3 is that, or CAB3 or amendment number 3 is that it will be thrown out by the courts and it will be declared nothing. In other words, it will be declared null and void. That option is not an academic option. It is a real one because the arguments being advanced are also very real and substantive. I think most people of the public may now be aware of the arguments that are being put. One argument which has been taken by Monsora, for example, is that it insists that you need a referendum for you to take away the right of Zimbabweans to vote directly for the president. So there is that referendum challenge which is before the court, and it will be very difficult for the court to say that a referendum is not required. But we'll wait to see. Another challenge is to say that Parliament did not have the power to amend the constitution and to grant a benefit to those who are in place, like to say the president who is there gets an extended term without a referendum, without a vote, that the MPs, the parliamentarians who are there, get an extra 2 years without an election or a referendum. So that is the second sort of challenge. We find it difficult for the court to say that the parliament did it properly. Then there are a number of other challenges which go to the procedures that were followed, that some amendments which came about had not been notified to the public. So we have engaged leg one or gear one of our challenge. In other words, if we answer the question, what next? There are court actions in place, and these court actions must be taken seriously. We will start to first cases that will be heard in September, mid-September onwards. We will be hearing this. So there is room for everyone to be very optimistic that the courts may actually on this matter be independent and grant what we would expect that it be granted. Then the second leg of our strategy has been political civil action, peaceful civil action, which is what brings in July 31. July 31 was an initiative by citizens. It was not called by any specific named organization. Certainly, in our organization, we didn't call for July 31, but we supported it once it had been called by the people that called it, which was not a defined organization, but the people on the ground. And even at Sungano, Ivano, Ubumbano, Lompakat, it didn't call, but it gave its support to that. I also know that the National Dialogue Platform, which is headed by Professor Mandaza, also didn't call for July 31 itself, but they put their support. So it was a very important initiative because by every measure, it was a huge success. The indication of success is in the level of consciousness across the country. Everyone knew about July 31. Everyone had something to say about it, that they were against it. And then the government itself was in panic mode, as we saw. They paraded soldiers, police officers, intelligence officers everywhere, and were really trying to show off that they have the power, but ended up not being able to find anyone clearly to suppress, because people chose that they would stay at home and not necessarily go out to the demonstration. So 31 July was the first action under the second leg of peaceful civic action. As far as I see it, what next after 31 July? It will be more and more of these civic initiatives. But the next one that is coming would be fully owned by the leaders that are currently at the forefront of opposing CAB3 or Amendment number 3. The next actions would be identifiable. They will be called, the dates will be announced by leaders from across the spectrum. Certainly, from our organization, we will be identified as one. I have no doubt that legal action and peaceful political action would yield a result. I think that the better way of putting it, as far as I'm concerned, when I say what next, I would urge that we get some review end of September. I suspect that by end of September, we would have had tangible results one way or the other where we would be able to say, this is how far we've moved. For me, I'm very optimistic that by end of September, we would have put an end to the amendment, one way or the other. Eventually, this amendment will collapse, and there's no doubt about it. I wish you just then to close my submissions or presentation by saying that the amount of opposition to this amendment is such that it is impossible to fail. It is impossible to, we will not fail. That is how I want to put it. Might not have come out properly. It is impossible for us not to succeed. We will succeed. We will be able to get and galvanize the opposition, because it is unthinkable that Zimbabweans would allow ED Mnangagwa to remain in office merely at the instance of a few people, very few people, who are doing it for their own ends, who are doing it for their own processes, etc. The only support base you have for this is that support base of the elite that is supporting him. Then we also know that there is opposition from ZANU-PF, but we will not necessarily be counting on that opposition until it shows. I would close there, knowing that there are other people who would speak, and I think that that would be my input to the discussion.
Well, thank you, Professor Maduku. It's very clear that the legal action, we'll probably start hearing the outcome of the applications as from mid-September, which is roughly a month from now. Seeing you are a member of the legal fraternity in Zimbabwe, what have you overheard as to the possible reaction to the applications, the possible responses? In the last discussion we had with you here,
we know you. Are you referring to the, are you hearing me?
Yeah, I'm asking. Can you hear me? I'm doing a follow up with you. Can you hear me?
Yes, I can hear you. You are referring
Yeah,
to
I was
yes,
saying
I can
that
hear you. You had said that. What
a
are we
member-
hearing as a possible reaction?
Yes.
Yes, I
What
can.
are you hearing? I just want to recall that in the
Yes,
last
I can
discussion,
answer now.
no, before that, in the last reaction on this platform a few weeks ago, you pointed out that the initial response, as contained in Justice Bharat Patel's initial remarks, indicated the possibility, the high possibility of this CAB3 being rendered what it is, i.e. illegal and unconstitutional. Do you still hold that view?
Very, very, very much so. Very, very, very much so. In fact, this is why I talk about end of September. So it's good that today you put us on and on this platform. I'm sure I organize another at the end. I'm very much, very, very much of that high opinion that one or other of these actions that have been filed in the courts will succeed, because they have begun the process of answering. We now have responses that they've given to some of the applications. The answers are completely stupid, if I may say that. I'm allowed to say that. Most of the answers don't make sense. They make some legal arguments which cannot be accepted by any self-respecting court. They forget that they are in the highest court of the country. I don't see judges taking or accepting the legal arguments that are being put. So we have started receiving the answers to their actions. So soon we'll be making the written legal arguments, and then a hearing will take place. So for the benefit of the listeners and the public, I'm still very, very optimistic that CAB3 will be thrown out. It will be rendered illegal by the courts. One of or all of those actions we have filed in the courts will succeed.
But given the disdain with which the authorities have treated this whole exercise, the contempt for the people, the roughshod manner in which they push through parliament, and even the boastful that is accompanied, the boastfulness that is accompanied. I heard Mnangagwa speaking at the Heroes Acre on Monday, literally boasting, making a caricature of those who opposed it, almost like saying go to hell. What is the likely response of Mnangagwa and the state to rejection of this CAB3 as illegal and unconstitutional? What do you anticipate as the reaction therefrom?
Okay, thank you very much for those questions. First, I must put in context the approach that they are taking, this approach of boasting, this approach of really showing disrespect, this approach. It's actually a well thought out strategy to try and bribe the judges, or try, I'm not bribing, putting bribing in courts. They want the courts to think that it will not be wise to then determine this matter purely on the merits. They want the courts to take the attitude that, well, this thing's already water under the bridge. So the political temperature in the country is that this thing is already accepted. It's already now water under the bridge. It's actually targeting the courts. So when you hear Mnangagwa doing that, he is very clear in his mind that they haven't started. Once those challenges are before the courts, they know that they haven't started and anything can come out of the courts. So I always follow what they're doing. It is meant to send some message, whether subtle or otherwise, to the judges to say, look, there's no need to keep going. It's like, wow, they dealt with the land question when they created the impression that the land question would not be something for the courts. This is about, the liberation struggle, all things, so that when the courts were then with the land, of course, with the land, it's a different issue, but with the land, the courts took a cue from the politicians. They started the censorship, I would put that word again in courts, where the courts had to devise legal strategies of making determinations that were in favor of what was thought to be what is required. That is very different from CAB3. CAB3 is, like it has been said correctly, it's a coup against the constitution. CAB3 is grabbing power. CAB3 is dictatorship. CAB3 is greediness. CAB3 is oppression. And the judges are aware of that. So they know that they will not be free themselves. Also, even CAB3 undermines the independence of the judiciary. There are a number of provisions in the amendment which undermine the independence of the judiciary. So the judiciary is very much aware of what CAB3 represents. It represents this appetite for undermining constitutionalism, which any self-respecting judge has to realize that they have a historical mission to put a stop to it. So Zimbabweans must expect that they might finally even get a judgment of the courts doing so. So that will take me to your next question, which says, if that were to happen, if the courts were to say, look, this is unlawful, this is illegal, and so on, Mnangagwa and his group, they will attempt to relaunch CAB3, because obviously if the courts are going to do it, they are going to do it via procedural grounds. They are going to say that you have not followed certain procedures, or you have not done it properly, or you need a referendum. The Mnangagwas are not going to give up. They will try to redo this. If it is a referendum that is required, they will then say, well, we'll go for the referendum. Then try to use all these churches that he has been visiting. And I know that he keeps going around, the various apostolic sects, and other churches like Bishop Mtendi's ZCC, you'll try to galvanize, or recently what they did with Madao's AFM. You saw what Bishop Madao did when he was declaring himself a member of ZANU-PF. So if that were to happen, it depends on what the courts will say. If the courts say a referendum, the regime will accept a referendum and then try and rig it. But we will not allow that. They will lose the referendum. And then if it is not about a referendum and the courts say CAB3 is illegal, they will try and redo. So we are not going to allow it. If, for example, they want to get another bill with now properly done and taking it back to Parliament, then we will not allow that. I mean, this time around, Parliament will not be allowed to sit. So if the courts give us a good result, that will be, as far as I'm concerned politically, that will be the end of not just CAB3, but also, of course, the president would have to resign at that stage. I'm not sure whether you're still hearing me.
Yeah, thank you very much indeed. Sorry, I had muted. Thank you very much for your response. And I want to follow up immediately with Jameson Timber, if he's there, to ask him the same question. Jameson, are you there? Again, Jameson has disappeared, as usual.
And if you have another question,
Douglas Monzora, can I follow up with you? Cesar, can I follow up with you?
Yes, thank you very much. I hope you can hear me.
I can hear you now. My question, which has been responded to by Professor Maduku, I want to repeat the question to you. What do you expect to happen in the event of the courts doing what Professor Maduku describes as that which is logical with any self-respecting lawyer, judge of the Constitutional Court? How do you think that the Mnangagwa and the state will respond if the act is declared unconstitutional and illegal? Not to mention the process whereby it became an act subsequently signed by him. What do you think?
I think if the bill were to be declared unconstitutional in any way, they have two options. The first option, of course, is to present the bill to referendum as is, and try to have an unfree and unfair referendum. But our assessment is that the referendum will be a landslide on the part of those opposed to the CAB3. So that will be their first, the one possibility. Go along the judgment, have a referendum, maybe constrict the time within which the referendum must be prepared and held. You remember in 2013, Mugabe gave us, I think it was 14 days notice, I think. Something as ridiculous can be done by this government if they think that doing something chop will caught us unprepared. And to buttress this view is the fact that ZANU-PF has been campaigning to the people of
Tesara, we can't hear you now. We can't hear you. I'll come back to you. Karen? Karen, are you ready to come in?
Yes, can you hear me?
Same question to you. How do you, what's
these
the likely
eventualities. So
trajectory?
there needs to be continuous.
He was talking all the time.
We can't hear him. Carry on, please.
So sorry. So what I had said is that
the last
there are
we heard
two,
from you, the last we heard from you was that they are likely to go for a referendum, a rushed referendum, in order to achieve their end.
yes,
After that, we didn't hear what you had to say.
To catch the people napping, hope to catch the people napping. And,
okay, Ramondora, let me park you for a while. Let me move to Karen Zingizi from Zipa and ask a broad question. What is the likely trajectory of this process? You have heard from Professor Maduku, who feels very strongly and confident that this act will be rendered by the courts illegal and unconstitutional. What is your view, Karen?
Yes, thank you. I have looked at I'm quite happy about the confidence that Professor Maduku has. But if you look at what is happening in the whole of Africa, not only Zimbabwe, there is this tendency of presidents that are extending their terms. They have got this argument that they are selling to some of their supporters that following Western democracy is preventing us from developing. I'm not saying, I'm not skeptical that we will win, but I'm saying we should actually go deeper with this problem rather than think that we will win it overnight. Please, can someone mute Monzora? So I've noticed that these changes to the constitution have happened in Guinea in 2020, which allowed Alpha Conde to run for a third term in 2020, and theoretically a fourth term in 2026. In South Sudan, the same thing happened. Amendments and a new unit government extended President Kiir's mandate to 2023. In Angola, in 2021, constitutional reform set their terms. In Chad, transition allowed Idris Deby to die in office. A new constitution later reinstated 2-term limits and changed terms to 5 years. We can go on and on. The Central African Republic, it did the same. It is now unlimited 7-year terms. Guinea, after 2025, it is now a 7-year electoral cycle, which can be extended to 14 years. Benin, 2025, the same constitutional reform, 7 years again. With Zimbabwe, Zimbabwe takes the biscuit because it actually also removed the vote from the people so that the president is voted in by the parliament. It is also moved the voter registration to the Registrar General and created and abolished the delimitation commissions. Burundi in 2018, 5 to 7 years, and those 7 years are for 2 terms, which is 14 years. That's why there were so many refugees from Burundi all over Malawi, everywhere, opening shops. They had crisis in their country. Rwanda, 2015, it did the same. I'm not being defeatist, but I'm saying we should look at what is happening in Africa overall, not look at individual countries like our little Zimbabwe, what's happening in South Africa, what's happening in Malawi. These things are interconnected. And the solutions we are looking for should be also interconnected. I'm very glad that Professor Maduku pointed out 2 of the 4 tracks that I see people should be looking at. He looked at the legal and constitutional track, which is going very, very well. We applaud that, whatever our legal comrades are doing, and they can win through that. Will the judiciary be bribed or not? It's very, very difficult to tell, because it's not only bribes that are working, it's also serious intimidation. So he touched on that track, legal and constitutional, and he also touched on the civic and societal track. We have to look at that in terms of the region as well. Here in Zimbabwe, they can come and stop people from having a rally or for assembling, but can they stop a community that is assembled to discuss their water delivery? If little communities meet to discuss service delivery, that would be also another tactic of what can be done to fight this this law, which is historically going back to probably the 1890s or 1920s, taking away the freedoms of the people, taking away the vote from the people. It needs a proper fight that can win. So I'm going to add to what Professor Maduku said, this civic and societal track, where the CDF is doing that. I think they're doing that. And also the Gungano Revanu is doing that. And that can be extended, like when nurses have got their strikes, they are not talking politics. They cannot be harassed in terms of wanting to take over politically. They want something delivered to them, which is good salaries. The war veterans, they've got a case they won under Judge Mangota. They should be allowed to meet and follow that court judgment so that it's fulfilled. Those are societal movements that can also be used by our learned professors and their various entities. And not one method can achieve results. It has to be all four of them, including electoral and parliamentary track. We have seen some parliamentarians oppose this CAB3. We're sure some of them still oppose it, but they're scared to say it. We know definitely that Vice President Chiwenga has opposed it. And Professor Maduku has mentioned that there could be some in ZANU-PF who are opposed to it, but we wait to see whether they can join the progressive bandwagon. So those are the four tracks that I see, and I'm glad that our learned legal people are doing it. Did people in these other countries ever fight and win? Yes, a few did. I think recently we know in Malawi, Malawi managed to have a rerun. I think I've got the research somewhere here. If you want me to talk about it, I can. But some of them have used these tactics, and the tactic that I've seen working better, especially like in Nigeria, it is this allowing the people to know what is owed to them, and then they have these civil movements for service delivery, because the government is always announcing, we are doing this for our people, we are doing the roads for our people. There's no medicines in the hospitals. People can organize around, we want medicines in the hospital. And already that is an organizational thing. So the regional bodies as well, like SADC and the African Union, they have to be held accountable to making sure that Africans on the continent are receiving a good deal from their governments. What is SADC doing? What is the AU doing in terms of all these presidential activities that we are seeing all over Africa, as if it is...
Karen, you are begging the question.
Yes, I am. Yes, I am.
Because basically, you know that SADC has done nothing about this at all.
Yes.
Not even a statement from the AU on the subject. So and
what?
Of course, we draw comfort from what Professor Maduku has said about the likely outcome in the courts. But I think our discussion is not just about Professor Maduku also referred to political action. We want to know here from people like yourself, Zipa in particular, what do you regard as the trajectory of the political action? Is it confined merely to defeating, let me finish, defeating CAB3 and restoring the electoral process and having elections even with before reforms? Is this fight against CAB3 all about restoring the electoral process without regard to the outstanding reforms? Is it about going beyond? Some of us, as you know, in the National Dialogue Forum, we've been calling for the National Transition Authority as the option.
Yes, I was going to go there. I was eventually
yes, thank you.
So Yeah, I think people already know about ZIPA now. We've been trying to explain to people what we are all about. We have seen the paper that was written by our generals who are also under ZIPA now. ZIPA has united all the different war veterans, even though they can still run with their separate entities. And we are actually begging to be for the other groups like Sungano and all these CDF and all to come under that umbrella. Remember that the party ZANU-PF always uses the fact that they are the revolutionary party. We fought for this country and no one else is going to take it. Chris Mchagwa is very good at saying that, well, there is a covenant that was done during the war, and that covenant is like a charter that later led to the very constitution that they are violating. So I think that is a very strong standing point to own that narrative, to own the vanguardness of the revolution. Who is the vanguard? It is ZIPA. It is no longer ZANU-PF because it has been infiltrated by people who were, some of them who were for Fumore Ropa or Mazakutsaku, who had agreed with Smith that the black people can be their horses while they are the riders. No, the black people fought for complete independence, to be the riders themselves. So ZANU-PF, as far as that revolution is concerned, it no longer owns it. So it cannot be used against the Professor Madukus of this country that they didn't go to war, so they cannot say anything. They can say anything they want under ZIPA. And ZIPA is working for a national dialogue, because we cannot have the same people come and repeat the same thing. CAB3 was going to cause a crisis in the country, whether it failed or whether it wins. So even if you go to the courts and you win, there will still be a political crisis in this country. And to deal with that political crisis, we need a national transitional authority. It just doesn't come from Norway. We cannot just have anyone come and say, oh, I can be a progressive member of that national transitional authority. It will have to start with a national dialogue where every progressive force in the country who is interested in seeing the country go the way it's supposed to go after a revolution, after independence, comes to that table for that national dialogue. And from there, they create the National Transitional Authority, which then has to have time, ample time, to change to reform, if not to educate different sectors of our country, economy and politically, like the security sector, the army, what is exactly is it supposed to be doing and how far can it go? All these things have to be clear for the people and for those people who are discussing it. And then the National Transitional Authority can then hand over the power back to the people. The revolution was always about handing over the power back to the people, not for the fighters to own it, but to hand it back to the people. I don't know whether that answers you, Ibbo, or should I?
Thank you. Thank you. I'll come back to you. Maybe Jameson Timber has joined us again. Jameson, I note from you have just said, as part of Sungano, I stand by and abide by the remarks of Prof. Maduku as they are the collective position of the coalition. I think that will be the position not only of Sungano, but even the National Dialogue Forum. But what is it that you see as a possible trajectory beyond the court action? Whether the court does what we expect them to do, as Professor Maduku, a renowned constitutional lawyer himself, has made very, very comprehensively in his submission. What then happens if the courts reject this illegal and unconstitutional act? Jameson Timber. Jameson. Cesar, are you able to come in? I see you.
Yeah.
Have you improved your connectivity to?
Yeah, I think so. I think so. I'm somewhere where there is stable Wi-Fi now.
Okay. Carry on. You can answer the question that I put to Jameson Timber.
Okay.
You had said the last remarks you said were that they might want to have a rushed referendum in response to what might be the negative position.
Yes, that's correct. Then the second possibility is that they may withdraw the bill and redraw it, depending on what would have caused the judges for the referendum. So, for example, if the judges rule in my case, where I am challenging the right to the removal of the right to vote, needing a referendum, they may then remove that and say the president can still be elected by the general populace, but CAB3 then remains. So they will have to amend the CAB3. But everything is possible with ZANU-PF. But if I may quickly say, we need to understand the stance that ZANU-PF has taken after signing of CAB3 and the suppression of the July 31. They have demonstrated their determination to close the democratic space via use of the law, the constitution. But they've also demonstrated that they are prepared to use brute force to stop any public expression of this expression of public dissent. So they are very, very determined in that regard. It is important that we fight in the two arenas that Professor Maduku has said, the legal field and the political. In both these fields, it is important that our people understand the cause. So there is need to summarize the court cases in a language that everybody will understand. For example, what does court case A seek to achieve? And so on. And then in small pamphlets or whatever publications, we make the people aware. We must not think that the justice of our cause is self-evident. So civic education is very important, even of the court cases. And then civic education regarding what we are fighting for or what we are fighting against is very, very important. And it is put in vernacular, Shona, Ndebele. It is also put in language, pictorial languages. I've seen cartoons from other organizations. And then there is still need for diplomatic offensive. I know that there's great skepticism about SADC, about the AU, but we must approach them. We must keep the pressure on them. I don't think that they think in a homogeneous way on this issue. Already we know that at one point South Africa went and pressurized President Chiluba against extension, and they did succeed. So it is important that we organize ourselves and launch a diplomatic offensive. We should never allow the debate to die down. Then lastly, there is always need for pressure on the judiciary. That is achieved through turning out in our numbers. I have seen from my platform today that already the case, at least the case that I am handling, has now been referred to the Chief Justice for directions. I am expecting that the other court cases will go through the same mill. That means that they want to hear and dispose of the cases very, very quickly. So we need every time that there is a court case to throng the constitutional court, to flood the constitutional court with our people, because there is always the pressure that this gives to the judges. And then lastly, regarding the court cases, it is important that lawyers find time for each other, the lawyers that are handling various cases, and deal with the common problems that always come from the Constitutional Court. The Constitutional Court has never done substantive justice on any issue that I remember. They always go technical and so on, and they are trying to go they will try to go technical on these issues. Already from the responses that are coming, especially the response that came from Mudenda today, Mudenda is saying that the right to vote was not affected at all, and that Zimbabweans have the same right that they were enjoying before the amendment. It has not been touched, and that those who think that the right to vote has been affected are misreading the law and so on. So they've also got very technical. And they are also saying that if the amendment does not say, I am amending the right to vote, even if it is, then that is not an amendment for the right to vote. They are advancing that argument and hoping that it will succeed. So we should brace ourselves for technicalities by making sure that we plug off the gaps. And therefore, lawyers must be coordinated and must have time to discuss with one another.
Just a question while you have the floor. What has happened to the 210 constituency challenges? The 210.
I am not so sure. What I do know is that some of them were not opposed. In other words, the MPs didn't oppose them. And one would have expected that some default judgment should have been obtained. But I don't know. I think PT was handling that. And we need to follow up on those very, very important matters. What I do know is that some of the cases were not opposed, and there is need to take advantage of that.
That's interesting. I don't know, Professor Madugu, are you aware of this, the 210 constituency challenges? Professor Madugu?
Yes, you are saying, I didn't get his last
The
bit
question
on
is, what has happened about the 210 constituency challenges? And
oh yes, they were actually put in.
Yes.
They were put in, as far as I know, they are put in abeyance. They have not been prosecuted by the persons that put them there because there were no responses in many of them. So the person who were pushing them, they simply didn't pursue them, but they are still in court.
But you heard Monzora say that some of them were actually successful to a certain extent, but there was no follow-up.
Yeah, because there was no opposite.
My question is there a chance of aligning those constituency challenges with the broader applications that you are making?
Yes, I think that should be possible. I hadn't appraised myself of the latest, so perhaps Dag is clearer and is closer to what would have happened there. But certainly they would have to be aligned. Yeah.
Yeah.
Yeah. What is important? Yeah. What is important in a scenario like that is for the lawyers to follow up the unopposed ones, and then set them down, and the Constitutional Court will still allow some argument of some sort, even if they are not opposed. But it is important to follow them up, secure judgments, and take advantage of those judgments at a later stage. Already, those MPs were barred. In other words, they are no longer allowed any right of audience.
Yes.
So it is important to follow them up.
Yes, I'll get back to you. Just Timba, are you able to come in? The question, the last question to the four of you is this: what is the nature of the political program? We know Karen has given us an indication from ZIPA that the National Transition Authority is a necessity, given our current political and economic circumstances, a necessity as a precondition for the recovery or restoration of democracy, which is an accountable executive, a vibrant parliament, and a fiercely independent judiciary. That these are all absent in our society, and that therefore, and has been so for a long time, and that therefore NTA is a precondition for that. What is your response to Karen? If I may start with Timber. Timber, it appears you are determined to keep silent. Timber. No. So let me go back to Professor Maduku as the last question for the evening. What is your response to what Karen has put on the table as a necessity for the National Transition Authority as a precondition for recovery or restoration of democracy in Zimbabwe, whether or not the CAB3 is defeated illegally, or that the state digs in and tries to fight its way out? What is your response to that?
Well, I think that there's no doubt that as we fight these processes, we might have to consider options outside the current framework. So the issue of a transitional authority and so on would come in depending on how successful we become in fighting the amendment. Certainly, if we fight it and succeed, I think that there should be room as a precondition to anything to reorganize how the state is managed before we move to the next stage.
Yes, but it would be good to give the public and the population at large a broad indication, because the main narrative, even from the process which was responding, through which the response to CAB3 was expressed, there appears to be an enduring belief in elections as a solution. And this has been so since 2013, if I may say so. The hope against hope that elections are the solution. Can we get a response that says that this is not so, that we have matured out of experience, that we need to go beyond that? Tejara Monzora.
Sorry, I'm not so sure whether I understood the question. Sorry.
Oh, the question was really the narrative so far with respect to the fight against CAB3 has implied almost singularly that the solution is the restoration of the right to vote in the electoral process without commentary on the history of elections so far. Namely that these elections cannot be fair and credible until there are reforms necessary to make them so.
Yes, I think you are correct. The main thrust of the fight against CAB3 is protection of the right to vote. But the right to vote in itself may not answer to Zimbabwe's political conundrum, which is the incidence of unfair, manipulated elections. And therefore, there is need for a small hiatus, a small a transition, as it were, where the electoral playing field is evened. So the idea of a transitional body becomes necessary. And this transitional body must have, in the political sense, limited mandate to prepare ground for a truly free, fair, and credible election. So in order to plan for that, to achieve that, the idea of a national transitional authority
becomes attractive, but it has to be carefully couched to make it clear that it is transitional, and to make it clear that it is preparing for greater and better and enduring democracy. So I think it is possible, and our people can be convinced that this is for the greater good. Remember that a proper construction of an NTA is something not very democratic, because you are not going to have elections. But this is for a temporary time while we are preparing for a truly free, fair, and credible election.
No, thank you very much. I think that's a very clear statement. May I turn now to Karen again, and perhaps respond to Douglas Monzora's position. He has accepted the idea of a transitional arrangement, as he calls it, as a precondition for the way forward. And Jameson Timber, who has not been able to connect, given the connectivity problems he's facing, he also endorses your position. My position is that dialogue must determine settlement. So the idea, the point you made earlier on about the need for national dialogue leading to a national conference, and then which will then agree on the nature and structure of the National Transitional Authority as an outcome of dialogue. Can you comment on the kind of the trajectory that the DF, the National Dialogue Forum, has so far come up with?
Yeah, the National Transitional Forum at the moment has been calling for unity of all the players, all the progressive players. I think this will also solve the problem that Comrade Monzora is seeing, that it might not be democratic because it's not elected. But if all the progressive forces that are looking not only at CAB3, but are trying to preserve the independence of Zimbabwe, come together in that dialogue and no one is left behind, I think it can be democratic to that extent. And also the fact that it's temporal, it will be temporal. I don't know how long the transitional period will be. It depends on how hard people are working on it. But it
depends, as Jameson Timber is implied, it depends on the nature and content of the dialogue, national dialogue. It must not be something that's before the dialogue takes place. It must be an outcome of the dialogue process. So the process itself will determine how long it takes, but as necessary as in that it must reflect the will of the people. And I think the point has been made before that it will be subject to a national referendum, the transition authority. It must have the support of the people through a national referendum, because it has impact on the kind of changes that are necessary or the process that are necessary if in keeping with the Constitution. If I then, on that note, I can now just ask if for the last word from each of you. I'll begin with Tezara Monzora. The last word from you.
Thank you very much. My last words are that, ladies and gentlemen, the signing of the CAB3 and the closure of the democratic space has once again strengthened our cause. And it has also given us a rallying point. We have something to unite on, and we must nurture this unity. We must keep on knocking. We must increase our defiance. We must increase our positive arrogance against these people. We must fight in each other's corner, and we must unite. And I want to thank the organizers of this event today for the job well done.
Thank you very much, Tezara Monza. Thank you. Tezara Maduku, your last word for tonight. I know we'll be worrying you again and again as we go forward. Your last word, my honorable constitutional expert, Professor Madugu. Last word from you. Perhaps we'll go back to Karen. Your last word, Karen. Karen.
I forgot. Yes, I'm here now. Yeah, I think just to observe that each of the tracks that have been discussed here cannot win this fight on its own. It cannot change a captured structure like the captured structure that we are looking at, just one focus. So I'm glad that today we have agreed that besides the political and legal focus, we start focusing on this other dialogue thing. Thank you.
Thank you. Professor Madugu, the last word. Professor Madugu has bailed out, is he? Well, if so, I want just to say the following, that we have received very strong reassurances here from the legal minds on this platform that the CAB3, which I described at the outset as a Pyrrhic victory which has been a major cost to the state, where the toll or damage suffered makes the win feel like a defeat, that we are likely to have the Constitutional Court reject CAB3 as illegal and unconstitutional. And if so, we expect that the state will dig in, fight like hell. But that might also, as Professor Madugu has indicated, mark the end of Mnangagwa and his regime. Because if they do go for a referendum, which is likely, according to Douglas Monzora, they will try and rush it. But given the mood in the country, it's likely to return a no vote, the referendum. This has been consistent with the history of referenda in Zimbabwe. Just when people think, maybe we'll go back to the PS Commission, just when everyone thought that the population was docile, it accepted UDI, there was a shock and a no vote. And likewise in 2000, when the state appeared confident that it had created a magnificent document, which appeared to be so, but in as far as the people were not happy with it, it was rejected. So we can go on and on. So we're here to say precisely, this is why they didn't want to go for a referendum in the first instance. So I would say I doubt that they would resort to that. They may resort to other methods, which we can only know on the date comes. And we are pleased to hear that we should be getting the court applications being looked at from mid-October, a month from now. Last but not least, we have also affirmed that this political process, which has brought into play the Sungano coalition, pairing up as it is done with the National Dialogue Forum, the twins are pushing far beyond the fight against CAB3, but putting the country, the society, on a sound footing through a national dialogue process, which will lead to a national conference, which will in turn determine the nature and content of a transitional authority as a precondition for restoring democracy in Zimbabwe. And that transitional authority may vary from 2 to 3 years, but it's a precondition for return to the electoral process when the country has undergone the requisite political and economic reform. The evidence so far, the last 10 years, is that the elections alone have been a poor indicator of progress in Zimbabwe. That on the contrary, that we need to put aside the yearn for elections until the conditions for free, fair, and credible election are in place, and that it might have been a big mistake. The opposition had gone into the electoral process.
Ibbo, you're muted. Your connection's gone. Okay, folks. Thank you very much to all the speakers. Ibbo seems to have frozen. Thank you to Douglas, Lovemore, Karen, Jamison, and to all of you who've been watching. Just remember that tonight's presentation will be live, will be carried on YouTube in the following days. Good night. Thank you very much. And David, please hit the music.